state leaked the video had some impact on how he decided to testify would be a valid question.
Okay, that's, again, not what y'all asked.
Understood, Judge, understood. But I vehemently object to a mistrial. I do not believe that anyone here at this table has done anything.
And we are back, Y'all go ahead and hit that like button for me. I'm not going to beg today because I know you're going to do it. Now, check this out. We're going to get back into our series of mistrial madness. We're going to take a look at a few more mistrial motions. We're getting closer and closer to today, but we still have a little ways to go. So let's get into a few more mistrial motions to tide us over during this break. If you're watching this in the future, this is all occurring while we're on a 6-day break, but court's back tomorrow. So anyway, well, let's go ahead and get into it. Again, don't forget to like, comment, subscribe, and thanks for watching.
All right, it's Monday morning now, and I need to find out from you what your intention is with regard to whether you are going to testify in this case. You have been granted immunity so that the privilege of self-incrimination is no longer relevant because the state can't use anything that you might say in answer to their questions or any other questions against you. And you have been instructed with the benefit of counsel as to the consequences if you don't testify. So I'm asking you now what your intention is.
May I speak?
You can answer my question, please. And so you're under subpoena. The state intends to question you. Are you going to answer any of those questions? Are you going to testify in this case?
Well, Your Honor, I've been pressured from the get-go. You know what I mean? Like, even when I went to the meeting with Glenville, I have told him over and over and over and over. You know what I mean? This is on my conscience. I got to keep distracting myself every day because I'm being dragged down into here because of lies that I don't told. I'm tired of y'all bothering me.
Okay, well, I'm sorry that you're tired of being bothered, but you're under subpoena. It's a valid court order. So your decision at this point is, yes, I will abide by the subpoena and testify, or no, I will not abide by the subpoena and the immunity order, and I will be held in contempt for my refusal and put in jail. So which is your decision?
But I did the time for all my crimes that I was caught for.
Sure, this would not be any kind of punishment for any crimes you may or may not have committed. This would be that you have been ordered by a court to testify, and if you refuse to testify, you're held in contempt. You're saying, I refuse to listen to the court's order and obey it. And it is not a punishment, it is an incentive to have you change your mind and obey the court order. So which is your decision?
Can you explain it to me?
So we talked about it.
It's the same thing that Glenville doing to me?
It is the same order that is still in control. You have a subpoena for your testimony. That is a court order. You also have a court order that says anything that you say can't be used against you other than if you get on the stand and lie and it amounts to perjury, you can be charged with that or with false statements. But if you refuse to testify altogether, when you're under a court order to do that, then that is considered contempt because you're saying, I don't care what the court has ordered, I'm not going to do it. And then you'll be put in jail through the end of this trial. Or until you decide, you know what, I think I will testify after all.
So let me, Yana, I'm telling you to your face, you just said that something about it, they can lock me up for lying. I'm telling you to your face, this is all I do. And you're telling me that they can lock me up if I lie. But if I sit here and testify, so the E-way going to jail.
No, not with regard to anything that you might testify to that might otherwise admit to a crime or admit to your involvement in a crime. That's what the immunity order does. And I'm sure Mr. Melnick has explained this to you, and I know I've explained it previously, but none of that is going to result in you being put in jail because they cannot use that evidence against you to prove any of those crimes that you might incriminate yourself about. So are you going to testify or not? Do you want to talk to Mr. Melnick again? No? Okay.
All right.
Okay. All right. Thank you. All right. So I'm going to have you step out for just a minute while we get the jury in. Mr. Melnick, if you could step out with him, please. Just so. Thank you. Yes, ma'am. I am. I was going to see if anybody had anything to say first.
Your Honor, I'm going to renew my motion for a mistrial based on coercion by Judge Glanville. This is based on the fact that Mr. Copeland, having now been properly instructed that he would only be incarcerated until the end of trial versus his instruction previously that he would be incarcerated forever. He's now deciding to testify. I think at this point, it demonstrates the coercion by Judge Glanville. So I'd like you to reconsider that.
All right. I don't think it just demonstrates anything of the sort. I think it demonstrates that he's now been properly advised and he's making a decision anew. Thank you. Overruled. Yes.
Housekeeping matter. Is the Harvey rule still under your guidance, still in effect? Okay.
Yes, it is.
Thank you.
Okay. And so I'm going to have the jury out. I'm going to give them the 3 instructions that we just discussed. Then we'll have Mr. Copeland in. I'd like him resworn. And then you can pick up from whatever you want to do post 3 p.m. June 12th.
They give you move you somewhere else. You have to leave Atlanta. At this point, why is that such a bad idea?
Why is it such a bad idea?
To leave Atlanta. Why are you so scared to leave? I know this all you know, but there's more to life than the shit that you involved in. You gotta walk around with a bag with an assault rifle. That ain't life. You trapped in a war zone. You at war with your own friends though. You can't even get in the car with me because you scared I'm gonna knock your head up. What type of shit is that? How can you sleep? You see what I'm saying? Shannon and D gonna end up killing you, dude.
Mr. Short, you can just go ahead and repeat that.
Your Honor, we are in court playing what's supposed to be the redacted version of Mr. Copeland's June 10th, 2015 interview at approximately 3:55, say 45. It was just played in court. Investigator Dennis speaking to Mr. Copeland and essentially saying that Lil D and Shannon are the ones that are going to kill Mr. Copeland in the future. That according to my notes, that was not supposed to be played in front of the jury. The state was to redact certain portions of this transcript as was litigated a couple weeks ago, and the state assured us that they were going to stop at the appropriate times and pause at the appropriate times. That was not done, and it is a statement about it's prejudicial, it's bad character, it's a statement about my client's future dangerousness that the jury has been exposed to. And at this point, I am moving for a mistrial on behalf of Mr. Stillwell.
hear from the state.
Thank you, Your Honor. I have here, when we went over the redactions, the portions that the state was supposed to redact. And what I have here from this chart, Your Honor, is page 396, line 21, which begins with, I heard Shannon and D was shooting at niggas on Simpson Road. And I have that we were going to be redacting from 396, line 21 through 397, line 11. And that is the portion that we had just paused on before the objection was launched. So the portion that Mr. Shard is discussing was not, at least in the notes that I have, the portion that the state was supposed to redact, Your Honor. So we would ask for a denial of any mistrial at this juncture, given the notes that I have. And I also sent this over, the highlighter redactions, to defense counsel to confirm that the portions highlighted are the portions that need to be redacted. And no one brought up to my attention at all that I missed a particular highlight. So we would ask that it be denied.
And do you believe that you missed a highlight, or do you believe that what you highlighted is correct?
What I highlighted is correct. Based
All right,
upon my
I'm going to
notes.
take a brief recess and look back at all of my notes from them. All right, having reviewed my notes and Ms. Pursfield having reviewed her notes, they both reflect the same thing, which is the last thing that we all discussed was, and I don't have the timestamp, but I have the transcript page number, was transcript page number 389. And I made a ruling on that. And then we moved to the February 21st transcript. So it appears that y'all already had some sort of an agreement, and so we didn't have to discuss it. But Ms. Winfrey is that's what she was doing just now, is reviewing the transcript so we can see what, if anything, got said about that. So we're just going to do that right here, and we'll see what that reveals, if anything.
Email. I can't. I've checked my notes,
Yes.
and so there, and this is just one part of my notes, but I want to be clear with everyone. 396 line 21 is the beginning of a redaction. This statement that I objected to was on 396 line 19. So there's a distinct possibility. Of course, I don't believe that that's an appropriate thing for the detective to say, but there's a distinct possibility that I misstated the time that the redaction was supposed to start as 21 as opposed to 19, and that may have just, it's likely that was an error on my end. So I just wanted to be clear to the court on that.
All right. Well, that may be, but it appears to me that maybe this was something, from my notes at least, that the state and the defense had come to agreement on, and
Right.
not anything that the court was having to make a ruling on.
Right.
But in any event, if in further reflection, your notes of whatever y'all agreed to redaction wise would not have captured his question, is that what you're saying?
It would have been the agreed upon redaction as I have it is just after that. And I believe that's what Ms. Hylton was saying. Of course, I'm of the opinion that that was not an appropriate thing for the jury to hear, but I also recognize that I likely did not articulate that previously. I would ask for a curative instruction, just that the jury is not supposed to consider what was last said by the detective.
Okay. I'm happy to give some sort of a curative instruction. I mean, I think it's fairly obvious that this is pressure tactics and persuasive tactics and what have you on the part of the detective doing the interviewing, and not any kind of crystal ball that he has into the future stating any kind of facts. I don't actually think it's particularly damaging, but I understand. And so what language would you like for me to instruct them in?
I would ask that you instruct the jurors that they are not to consider the last statement made by the detective on the videotape before we broke.
As fact or whatsoever, or do you want me to say any suggestion made in the last statement, or just
That any suggestion made.
okay?
They're not to consider any suggestion made by Investigator Dennis on that videotape just before we broke.
All right. Any comment by the state?
Your Honor, we would object to a curative instruction. The entire passage of what Detective Dennis said, starting at line 10 through line 20, would put in context what the court just said. He starts off, to leave Atlanta, why are you so scared to leave this all? I know this is all you know, but there's more to life than the shit that you're involved in, dude. You gotta walk around with a bag with an assault rifle. That ain't life. You're trapped in a war zone. You're at war with your own friends though. You can't even get in the car with me because you're still indiscernible. What type of shit is that? How can you sleep? You see what I'm saying? Shannon D gonna end up killing you, dude. Like, I don't think.
Yeah, that's the part he's bothered about. The very last part about Shannon and Dee gonna kill you. Doesn't seem like the kind of curative instruction the state ought to be objecting to.
So, Your Honor.
Yes. Would you like to make a suggestion as to how to craft the curative instruction?
No, Your Honor. We just want to make sure that what is disregarded is the last sentence, nothing before the last sentence. Because we stopped it there, then we asked then there was a break. So the last portion, which would be, you see what I'm saying, Shannon D gonna end up killing you, dude. This is to disregard that Shannon D's gonna end up killing you by the detective.
So you want it to be more specific? Do you want me to say something like, you're not to consider a suggestion made in the last question by Detective Dennis about anything that Mr. Stillwell might hypothetically do? Or no?
No, I think that would be drawing more attention to it.
Okay.
I think if we just say the last sentence or the last statement made by Investigator Dennis, the jurors are not to concern themselves with that statement.
All right, you're not to concern yourselves with any suggestion made in the last question by Detective Dennis. All right. Anything more from the state on that?
My only concern, Your Honor, is that it was taking out the entire portion of that, because the last thing they heard is Detective Dennis before I pause. So they may think they can disregard all of it except for the last.
Well, you know what? It's just the question anyway. So that's the instruction I'm going to give. Mr. Steele.
Good morning, Your Honor.
Good morning.
Good morning, everyone. Your Honor, I just want to again put my objection. I didn't want the any recording to be played the way it's been played over our objection for this reason. And I don't know why anything that Detective Dennis said about, I don't know why you want to leave Atlanta and carry an assault rifle, that shouldn't come into evidence before this jury. So my position has always been the state has to ask a question. If they're going to impeach Mr. Copeland, then they can play the excerpt. But I just don't want it to sound like it was waived by some agreement. I never entered that agreement. I understand the Harvey rule. I'm not going back on anything I've said. But my objection is that it should never have been done in this manner. And we're just watching videos for a day plus. So my objection is that the state should never have played that portion at all from all the lines, 10 through 19.
Okay, because your objection is to the methodology
Yes.
in which they're conducting the impeachment.
Yeah, there's two. That wasn't impeachment. Detective Dennis' statements.
All right. Well, we had an opportunity to go line by line through every one of these statements and make more specific objections to questions or answers, and that was not raised with this court. So that is waived. With regard to whether you had an objection to the methodology of presenting the statement in full, that is a separate issue. And frankly, given that Mr. Copeland disavowed everything that happened in any of them, you know, I would have overruled that objection anyway. But all right, anything else for the record?
I don't believe I waived anything by my objection to the wholesale playing of the recording.
No, I don't think you waived that objection. I think you have waived an objection you might have had to this particular question by Detective Dennis, because we had an opportunity to make kind of very targeted, specific line-by-line objections to the things that were going to be heard in the playing of the recording.
I hope that if another court looks at it, that they will see my objection as being to anything that the state does not ask a certain question for.
All right.
So I believe it's encompassed.
Okay.
During these meetings that we had with each other, at any point, did you ever tell me that what little D told you about the night of Donovan Thompson's murder was a lie?
I don't even, me and you, only time me and you talk about it, it was just like, I told you that I made it up. And you were like, which part did I make up? And I was like, let D get into my car saying that this happened. And then you was like, so let D never got in your car and said that they killed him. And I was like, no. And you was like, why is this my first time saying it? And I was like, because I was scared. And then you was like, so you asked me about Noah, and I was telling her I didn't know him for real. And I just made it up. And you was like, and then you were like, well, I got to let the defense know. And I was like, damn, you going to tell them? And then you were like, I have to. And then I was just like, damn, don't tell them, because the defense already saying that, you know what I mean, too much that they don't need to be saying.
Okay. Isn't it true that it wasn't until you were about to testify that you told me some different things about what happened that night at McDonald's?
Because you made me feel comfortable.
Okay. And that is when you told me that it wasn't Nard that got into your car. It was Little D and Shannon that got into your car.
Huh?
Do you remember telling me on the day that you were going to testify that it wasn't Nard that got into your car on the day that Donovan Thomas passed away, but it was Little D and Shannon that got into your car?
I don't get what you're asking me.
Sure. Do you remember telling me, switching your story up, that it
No, I didn't switch my story, but I came forward. You made me feel comfortable, and I let you know, like, I lied. The D never told me nobody killed nobody when he got in my car.
Did you ever tell me what you told me on June 7th, 2024, is that Little D didn't say anything to you? That's what you told me, correct?
You just confused me again.
Sure. When we met in June of 2024, that's when you told me that Little D didn't say anything to you. That was the first time you ever said that, correct?
You said that was the first time I ever told anybody that?
Yes.
So I guess I don't get, like, I hear what you're saying, but I don't get it. I don't understand it.
It was only in June of this year, that was the first time you ever said that Little D did not tell you anything in the car, correct?
Because you the first person I ever spoke with that made me feel like you went after me. So it was like, you made me feel comfortable to let it be known that, shit, I lied. So I felt like you was somebody I knew. Okay. And I wanted to tell the truth to you that I made it up.
All right. Also, during these meetings, did you tell me multiple times that you did not kill Nut when we met?
Say that again?
When we met previously, did you tell me multiple times that you did not kill Nut?
Yeah, I think I told you that.
Okay. And did I tell you that there was other evidence that supported what you told me? What?
Sustained.
Did I tell you that, excuse me, strike that. Did I discuss with you that I could not show you any other evidence because you were a witness?
Huh?
Did I tell you that I could not show you any other evidence because you were a witness in this case?
No, you showing me the pictures and stuff and the phone calls that you gonna use. That's what you talking about?
I did show you that. Was there other evidence I told you that I could not show you because you were a witness?
I don't remember.
Now, Mr. Shard on cross-examination asked you if I showed you all of your interviews prior to trial. Do you remember that?
Can you say it again?
Do you remember last week Mr. Shard asking you if I showed you all of your interviews prior to trial? Do you remember that?
Can you just ask me this question? I don't.
Do you remember Mr. Shard last week asking you if I showed you all 6 of your interviews prior to trial?
If you showed me the interviews, what about it?
Do you remember Mr. Shard asking you if I showed them to you? Do you, Mr. Copeland, would you have sat down and watched 21 hours of interviews with me if I asked you to?
I don't even want to sit down right here and listen to y'all now.
Now, Mr. Copeland, after we met in June, you were supposed to testify on June 7th, 2024. Do you remember that?
All I know is I jump when y'all tell me to jump.
On that day, when you were supposed to testify, do you remember pleading the fifth?
Oh, when y'all locked me up?
When you got locked up because you pled the fifth. Do you remember that?
Mm-hmm.
Is that a yes?
I never forget it.
All right. And you went to the Fulton County Jail, correct?
That's where y'all took me to.
And then you went to the DeKalb County Jail, correct?
That's where they took me to.
And then on Monday, June 10th, there was a meeting in the judge's chambers. Do you remember that?
Yes.
And that meeting was with you. Slow down. Sure. On that Monday, June 10th, there was a meeting in judge's chambers, correct?
Yes.
And that meeting was with you. You were there.
Yes.
Your attorney, Ms. Bumpus, was there.
And you was there.
I was there. Investigator Long was there.
Yes.
Okay. Another investigator, Hamilton, was there.
Trying to little short bald head dude?
Yes.
Yes.
And there were some sheriff's deputies, correct?
A lot of them.
All right. And the purpose of that meeting was to explain to you what would get you out of jail, correct?
I don't know. I don't know the purpose of it.
Okay. Did we discuss you getting out of jail?
We been there for a long time.
And did we discuss you getting out of jail?
Yeah.
All right.
There was some of it.
And do you remember Mr. Shar and Mr. Steele asking you about those meetings last week?
I remember, I don't know which one asked me, but I remember being asked about it.
And is it true that there were some details missing from what they asked you last week?
You tell me.
During this meeting, were you able to talk to your attorney, Ms. Bumpus, on multiple occasions?
She sat right there with me the whole time.
Okay. And were there times when we left and you were able to talk to her by yourself?
I whispered in her ear.
Okay. But were there times when I left the room, the judge left the room, and you and Ms. Bumpus were in there and the two of you talked by yourself?
I think y'all probably left out before. I can't really remember.
And did I tell you in that interview that the only reason why you were in jail is because you pled the fifth?
That sounds like something you said.
Mm-hmm. And did I also tell you that so long as you testify that you would not be in jail?
Huh?
Did I also tell you that so long as you testified, you would not be in jail?
Well, me and you were going back and forth.
Okay. And did I tell you that so long as you testified, you would not be in jail?
Yeah, but I was explaining to you why I didn't want to testify.
And did I tell you multiple times in that interview that the state of Georgia did not want you to be in jail?
That sounds like something you said.
Okay. And I didn't just say it one time, I said it. Do you need some water?
Nah, I've been coughing all weekend.
Okay. Did I say it to you multiple times in that interview that we did not want you in jail?
I think you said it the whole time.
Okay. Now, in that meeting, did I also tell you that I expected you to tell the truth?
And I told you that. I don't lie. If you keep going to the past, if you want me to tell the truth, you can't ask me about what I done told the police because when you know what I mean, I'm just going with the flow.
And do you also remember during that meeting, your attorney asking me if he gets on the stand and says things that aren't true, would I be okay with that?
If I wasn't talking, I don't know.
Do you recall Ms. Bumpus, your attorney, saying if he says something, you're right, it'll be effect on it. If he says he did something and you know he's not telling the truth, what happens? And my response to you is, if he said he did something and he did not do that thing, and she said to me, if you believe he did not, so if you believe that he's lying about that, then I said, then no. If he admits to doing something on the stand and he did not do that thing, I'm going to ask him, this is the first time you're saying that. And she asked, and you have independent evidence to prove it wasn't him, then what? Then nothing. What do you mean? So she said, so you're okay with him if he got on the stand and said things
Ms.
that
Hylton, get to the question.
isn't true? That I said, no, I want him to tell the truth. What have I always said to you? I want you to tell the truth. I don't know what's going to come out your mouth, but I expect you to tell the truth. Is that what I said to you?
You told me that if I said I killed Donovan Thomas and I ain't killed him, you're going to lock me up. You said that if I plead the fifth, you're going to lock me up. And from my understanding, whatever I had to say didn't matter. From my understanding.
And let's talk about the part about Donovan Thomas, correct? Do you recall me saying to you, and this was when, we talk a lot about perjury back in the chambers.
What's the other word is too that I was saying?
Purge. Remember we talked about
Them
purge?
two different words. Okay, yeah, that's it.
Okay. Do you remember us talking about perjury, and perjury meaning lying on the stand?
I always get confused, but you know it.
Okay. And did you have your attorney ask me multiple times, if you testify and say something that I know isn't true, what would happen?
What you mean?
Did Ms. Bumpus ask me on multiple occasions, if you testify and say something that I know isn't true, what would happen?
You told me I don't know. I was trying to get it down pat what you were saying, but cause you kept going back and forth about it, cause I wasn't understanding it, the purge and perjury, cause it sounded the same to me. Okay. And I was telling you that the stuff I said in the past was a lie. You gotta ask me now. I don't know.
Let me ask you this. When the judge was not present and it was just you, me, Investigator Long, and the sheriff's deputies and your attorney, did I ask you, did you plan on taking the stand and saying that you killed Nut to help your friends out because you had immunity? Did I ask you that?
I think I don't know if you asked me that, but I know I told you that I'm not admitted to no crimes.
Okay. And did you tell me you were not going to admit that you killed Nut?
Yeah, I'm not going to admit that.
Okay. And did I then tell you that if you planned on claiming a murder that you did not do, that is when you would be charged with perjury?
That's what you just said. That's what I just said. You said.
All right.
If I said it right. And you asked me, when you questioned me, did I did? And I told you no.
So you talking about killing Nut, that, at no point did I ever tell you if you just admit to killing Nut, you'll be charged with perjury. Did I ever tell you that?
I don't understand you.
This entire, I apologize. I know I object. Entire 10 minutes has been Prosecutor Hylton putting her credibility before the jury without being questioned at all. I can't question. So I object to this entire line of questioning.
I understand. Yes, sir, Mr. Short.
Is the entire transcript now open for questions?
No, it is not. She's not even asking him things about the transcript right now. She's asking him things that happened not on the transcript.
Now, last week, I believe Mr. Shard asked you if I told you you could say I don't recall to every question. Do you remember him asking you that?
I don't know. He pissed me off too, so I got frustrated when he was talking to me.
Do you remember your attorney asking me, can he say I don't recall to every question?
Which lawyer?
Ms. Bumpus, in that June meeting.
I don't.
Do you recall Ms. Bumpus saying, can he say I don't recall to every question? And my response to her was, I will hope that is not the truth, because I think there are some things you do recall and some things you don't. But the things you don't recall, you don't recall. And I will go through my process of what I do. Do you recall me telling your attorney that?
See, y'all don't understand. Like, I think don't nobody in this courtroom know how I feel to be sitting right here. It ain't about what I recall, what I remember, what I don't remember. It's the functioning of my brain as I'm sitting up here. It's like I'm trying to answer y'all, but my brain is in and out. Like, I don't. You feel me? Like, I can't. You ask me. It's how you asking me the question. It better than I'm trying to comprehend what you saying, and then answer truthfully. But it sounds like a trick question because I don't know how to answer these questions. When me and you talk without being in the courtroom, you talk to me on a level where I can understand you good. But when you get right here, the question that you asked me, you made me feel like I'm in an interrogation room, so I don't know how to answer your questions.
In that meeting, back in June, a few months ago, do you remember me telling you that I just want you to be truthful?
Yes.
Okay. And do you
Overruled.
And do you remember me saying to you, I don't know what your current truth is, but I know what you told the police back in 2015?
Personal observations of a non-witness.
Overruled.
Do you remember having that conversation in the judge's chambers?
Yeah, because I told you that. Y'all don't know that. Like, y'all don't know. And you said that your mouth that, yeah, you're right. We don't know what you're going to say and what your truth is. So.
And do you remember me telling your attorney to talk to you about what impeachment is?
I thought they were the same word as the other perjury, whatever.
But
ain't they the same?
I can't answer that question for you, but do you remember, did I tell your attorney to talk to you about impeachment?
Talk to me about impeachment?
Yes.
I don't know.
Okay.
I know most of the time we was talking like my only thing was I was in jail and I didn't understand what was going on. I just felt like, I don't know.
Now, also in that meeting, you said, I did these crimes. Do you remember saying that I did these crimes?
Because I don't want my family I don't want my nephews and them to hear the stuff that I did.
Okay. When you said you did these crimes, what crimes were you talking about?
I don't recall.
When you say you don't recall, what do you mean?
That I ain't speaking on it.
Were these crimes that occurred back in 2015 or crimes that happened more recently?
I don't commit crimes. I changed my life.
So when you said I did these crimes and Mr. Steele asked you about that, or Mr. Shard, what crimes were you talking about that you did?
I guess the ones in my dream, the nightmares, whatever. I don't know. I don't get what you're asking me.
In that June interview, in that June meeting that happened a few months ago, and Mr. Steele or Mr. Shard asked you about this last week, you said, I did these crimes, I'm telling you that. And my response to you was, okay, I don't know what you're talking about. I'm asking you today, what crimes were you talking about back in June that you said you committed?
I ain't committed no crimes.
Are you saying you haven't committed any crimes recently?
The crimes I committed for, y'all locked me up for them.
Okay. So then when you said I did these crimes, were you talking about things that happened in 2015?
I'm talking about the crimes y'all caught me for.
Okay. And to be clear, were you talking about any crimes that are charged in this present indictment?
I'm not a part of it, so I don't know. I never read this indictment and don't want to read it or hear nothing about it.
And let's be fair. Were you in custody between June 10th, 2015 and February 2019?
Can you say that again?
Were you in custody between June 10th of 2015 to February 28th, 2019?
February 28th?
Yes.
2019?
Yes. God bless you.
Can you
When did you get out of federal custody?
September 12th, 22nd, one of them days, 2019.
Okay. And were you also incarcerated from May 13th, 2020 to May 11th, 2021?
I went back to jail. I did over a year.
Do you remember then going back to jail June 15th, 2021 to July 24th, 2021?
Yes.
Okay.
You said from when?
June 15th, 2021 to July 24th, 2021.
You said from June to July?
June 15th of 2021 to July 24th of 2021.
So you said I did a month in jail?
Yes.
I don't remember that.
Okay.
I remember going back to jail and both times I went back to jail after I got the feds, I was in there longer than a year.
All right. Do you remember then getting arrested in October of 2021 and then being released in February of 2022?
You said October?
Yes.
And then getting released in a year later?
And let me say, going to prison in February of 2022.
2022. Yeah, I went, yeah.
And you stayed in prison until August of 2022. Is that fair?
Yes.
Okay.
23,
And then you were transferred back to Fulton County in August of 2022, and you were in jail until March of 2023. Is that fair?
Yes. They sound like it.
And you've been out since March of 2023, correct?
Until y'all locked me up for pleading the fifth.
And you spent the weekend in jail.
Yes.
All right. Now let's talk about this October 2021 interview. On cross-examination, do you remember Mr. Steele playing a number of jail calls for you?
Yes.
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 And do you recall those jail calls being from December of 2022 to about February of 2023?
From December to February? Okay, yes.
Okay. And do you recall 3 of those jail calls were from February of 2023?
Shit, I guess.
Okay. And do you remember the 3 jail calls that Mr. Steele played for you? That was after the October 2021 interview that you did with Investigator Viverito was released. Do you remember that?
I guess.
Okay. Now, this is the interview that you told Mr. Sharp last week you thought that the state of Georgia released, correct?
I believe it.
All right. Now, you had a total of 6 interviews with the Atlanta Police Department. Is that fair? 5 from 2015 and then 1 from October of 2021. Is that fair?
I don't keep up with it.
Okay. Do you remember watching 5 interviews in court?
Yeah, I'm gonna definitely. I don't want to watch them no more.
Okay. And the only one you did not watch was the October one. Is that fair?
Please tell me we're not about to watch another one.
Is that fair that you have not watched
Yes.
the October one?
Yes, I have watched it. The world watched it too.
Okay. The only video that was ever leaked was the one from October, correct?
Yes.
Did you know, or are you aware that between the Fulton County District Attorney's Office and the Atlanta Police Department that we've had that October 2021 interview since the day it was recorded?
Can you say that again?
Sure. Are you aware that between the Fulton County District Attorney's Office and the Atlanta Police Department that we've had that October 2021 interview from the day that you sat down and did the interview?
Yes.
Did you know that we had the interview for 16 months in our possession before it was released?
Yes.
Did you know that we served that particular interview in discovery in January of 2023?
Yeah. I think I've got it.
Yeah, I
Ms.
believe
Hylton.
it is relevant to the assertion that defense counsel made last week when they opened the door as far as who released this interview. They questioned him. You're right. We objected.
Yeah, I mean, I think that is not a fair characterization. There was questioning about it.
And we objected to it, and it was overruled, Your Honor.
Mhm.
And he was allowed to answer it. And so we are following up on the ability that he was able to answer that question.
Follow.
I don't oppose that. It was on a jail call, but I would like to ask questions of the prosecutor. This is testifying.
All right, it's not testifying. Ms. Hylton, rephrase your question.
Are you aware that that interview was given to defense in January of 2023?
No.
Are you aware that the video was released within 30 days of it being given to the defense?
I'm going to object that they have any evidence they can bring it forward in court.
Overruled.
Are you aware that after the video was released, we brought the fact that it was released to the court?
All right, let's take a break. Time for a bathroom break anyway.
The predecessor court came to the court's attention that there was a release of what I'll call discovery. It's October 27, 2021. And it's a recording of an interrogation of Mr. Copeland. And it was very harmful to Mr. Williams. The part that was released that I'm aware of, and I believe Mr. Adams, unless he corrects me, just has lies, what I can say lies, about Mr. Williams ordering people to die. It was very harmful. I asked Judge Glanville, predecessor judge, for relief and a bond because it denied Mr. Williams' right to a fair trial. The predecessor judge said there's going to be an independent investigation of who released that and that he would get to the bottom of it. I never heard back from that. A jail call, I listened to all these jail calls. We had others listen to all these jail calls. On a jail call, I didn't say anything last week. I played a jail call where Mr. Copeland said that immediately after telling the authorities in December and February, December 22, December 23, that he had lied and that everything he said was a lie about Mr. Williams, and he's telling this to his friend and his sister. He said all of a sudden, this this interrogation released. So he believed it was the prosecution team releasing. That's how it all came up. For a prosecutor who's an advocate to then vouch for and put her own credibility in issue, that's what I've been objecting to. And to say, we gave it to the defense, and I'm raising my voice because I don't have a amplifier and a microphone. So I'm not trying to, yeah, court reporters shaking their head with a smile. My point is, I'm sorry, Your Honor, is that it sounds like I did something wrong. I didn't release anything. I didn't do anything wrong. I was the one objecting for the release of this information. And it was given out, and I'm not very technical, so it was given out on Dropbox, and I was told that's a bad way to do it. And Judge Glanville, then predecessor judge, said, don't do it that way anymore. Yet the Dropbox was never taken down. It was all a mess. And the predecessor judge, and I'm not casting aspersions, it may have been a great investigation. I just never heard anything. Now we're here on Tuesday, the 3rd day of September, and the prosecution is asking questions which clearly target that did you know that within X amount of time that the defense got this discovery, which the previous answer was no. I don't know when the defense got the discovery. There's no foundation. That doesn't stop the district attorney of saying then it was released. Clearly, it's the same pattern that they've been given about all these witnesses. Mr. Trotavia Stevens, Mr. Bean, B-E-A-N, Mr. Murphy, this witness. Have you ever had to testify in front of Jeffrey Williams or these other people? Now all of a sudden, your testimony is different. And I've been objecting every time because there's no evidence of intimidation. And what happened, which you may not know, and this is based on information belief, I never spoke with Mr. Copeland about this, so maybe it's not true. I believe he got beaten in the jail after that was released. I believe, I could be wrong. But assuming that's all true, for the prosecutor to now say that their hands are clean, and I can't ask the question. Judge Glanville denied my request to call the prosecutors and their agents to assert under oath, under questioning, who released this. Because it certainly wasn't in Mr. Williams' best interest. So anybody on Mr. Williams' behalf would be would do a disservice to release that Mr. Williams is having people killed when we're in the middle of jury selection. So anyway, my bottom line is this entire, Ms. Hylton has taken, and I have all the cases we argued before, but has taken herself, and she has moved from the position of asking questions and an advocate to testifying as a witness. You told me, I was there, Detective Long's out of the park. You told me, you only told me this. Did you know that the prosecution served this? Were you aware that the defense had this? All of this needs to be questioned to Prosecutor Hill. So I asked the court, I know I've been repeating the asking that, and I know that I have a particular objection, but this is nigh on trial cases in the state of Georgia. All of these cases require Ms. Hylton to take a witness stand. And if she does, I have no objection. I'm not a witness. But it's been denied. That's my objection. I'd like her to be removed from the case. I'm not trying to stymie the prosecution. They have other witnesses. They have at counsel table 3 other lawyers. I mean, this is not new. So I ask for the prosecution that specifically Ms. Hylton and Ms. Love to be removed from the case. I have questions for both of them. I also like to renew my motion. I can call predecessor judge. That's my entire objection. For the mistrial motion, I don't want a mistrial. I'm telling you what I don't want. This has to stop. And now those last questions had to be with the intent of casting aspersions on not only Mr. Williams, but I presume everybody else here by saying that we're releasing information, which I assume maybe it's not true. So I don't want to go too far. But the next question will be, and you got beaten, Mr. Copeland, after the release of that as intimidation. So those are my motion for mistrial that I don't want. I don't want the motion for mistrial, but I feel compelled.
All right.
That wasn't going to be my next question because I didn't know he got beat up in the jail. Your Honor, last week when Mr. Shard, I believe, asked.
He may not have. I just want to make that may not be accurate. I don't have any personal knowledge, or I was not told that.
Last week when Mr. Shard asked he went down a line of questioning about this call being released. And Mr. Shard asked Mr. Copeland who was his belief, what was his belief of who released this recording? And the state objected, saying that it wasn't relevant who he believed released this video. The court overruled the state's objection. He was able to answer that question, which was he believed it was the state. And at this point, we believe that it is proper for the same reason that he was able to disparage that the state will release such a video.
Okay,
Or-
you need to be careful about what you're saying, because there are questions from the attorneys and then there are answers from the witness stand, and that's what the evidence is. And I do not believe that anybody on the defense side made the suggestion that the state had released it. I mean, the transcript will reflect what was asked and what was answered, but
and maybe not disparage is the right word, but the question was asked, who do you believe released the video? And he says, I believe it was the state of Georgia. I believe that an appropriate line of questioning, Your Honor, is would he feel differently if he thought that the defense leaked it? And to give questioning about what his understanding of, what Mr. Copeland's understanding is of what happened and what transpired when this video was released.
well, we already know what Mr. Copeland's belief and understanding is.
But would it change if
That's not what you asked, though.
But I had to give some foundational questions in order to ask that question, in order to ask what my next question is. Because another question that I'm going to ask him, and it's something he alluded to earlier, was that after this video was released, Ms. Love, Investigator Long, Ms. Rolak all visited with him after this video was released to check on him, to make sure that he was okay. And he alluded to that earlier when he thought I was present at the meeting. And all of this happened around the time that the video was leaked. And so I was asking some foundational questions to Mr. Copeland to see if his position would be different if he thought that someone else leaked it and not the state of Georgia.
Then
and
you should have asked that question.
And I can get to that series of questions, Your Honor, but I don't.
I mean, you are coming very, very close to the line with this line of questioning. I mean, you're basically, the defense is not far off. Let's just put it that way.
So I can move to my last two questions regarding this, which is who came to visit him after the video was released, and would he feel differently if he believed that the defense leaked the video?
No, I'm not going to let you ask that last question at this point. I mean, that's a total hypothetical question. That is an assumes facts, not an evidence question. Not the objection you keep making.
Thank you, Your Honor.
Your Honor, I feel compelled to just make a brief record. First of all, any insinuation that I asked a question about the release is way off. That topic never even came up during my cross.
You know what? And I know you're not finished, but let me just say that I believe that this jury is paying attention and that they have enough wherewithal to remember what actually happened, and for questions that are potentially misleading, I'm not sure why they're being asked, but I think the jury's going to take note of what got said. And I understand, but I think the jury is doing what they have been told to do, which is to pay attention to the evidence, not the questions.
And second, Your Honor, I just want Your Honor to understand kind of the backdrop here. I guess there was a release. I don't even remember the time that it was released, but apparently it was on social media. When that came to the attention of the court, to my recollection, from my vantage point, yelled at the defense, and this was a prior judge, and essentially blamed us. And all of us were saying, well, we didn't do anything. I personally don't even know how to release a video to the press or the internet anyways. But, I just went along with it. Okay, there's going to be an investigation. We're being told we're under investigation. And then all of a sudden, no one mentions the investigation anymore. And it's kind of like, well, if you're accused of something, you would like to know the progress of said investigation.
I'm certainly happy to ask the predecessor court's chambers what's going on with it, if anything, but that's not really relevant to what's before this jury.
Well, it's not until the state, knowing that there was an investigation, knowing that they haven't heard of any findings, then lights this thing on fire again and starts suggesting that we did something wrong. And, I can only speak for myself. I don't believe anyone did anything wrong on this side. I know I didn't. And then somehow those insinuations are coming out in front of the jury with absolutely no basis. And I'm going to join my my friend Mr. Steele, and I'm going to state in my place that I believe the state at this point is goading a mistrial and goading us to move for a mistrial. So I just think that was very inappropriate, and it suggested things that there is just no basis. And in fact, there's apparently been an investigation, and it's been settled as far as I know.
Well, I don't know what has happened, if anything, with that. But would y'all like to address the assertion that you are goading the defense into a mistrial?
Yes, Your Honor. Number one.
Right, into a motion for mistrial.
Yes, Judge. Thank you. Number one, we don't want a mistrial. We vehemently object to a mistrial, and we do believe that the line of questioning, whether it was posed by Mr. Shart or Mr. Steele regarding Mr. Copeland's belief about who leaked that video, was one, not relevant, but understanding that the court ruled as it did, we believe that an inquiry whether his belief that the state leaked the video had some impact on how he decided to testify would be a valid question.
Okay,
since
that's, again, not what y'all asked.
Understood, Judge, understood. But I vehemently object to a mistrial. I do not believe that anyone here at this table has done anything, anyone at this table or on the state's behalf has done anything to in any way merit, warrant, call for, justify a mistrial. So we definitely object to a mistrial. And Your Honor, as it relates to the assertion that counsel for the state have somehow made themselves a witness, repeatedly the witness has affirmed that there were people in the room whom either counsel for the defense could call without having to disqualify either prosecutor in this case. So that being obvious, we definitely object to a mistrial, and additionally, we object to the speaking objections that are being made while the jury is in the box.
All right, well, I'm going to overrule that objection. I don't think that that is going on. Sometimes it's just not particularly clear what the objection is, and if I need further elucidation, then I have permitted that. But I'm going to overrule the motion for mistrial and or deny the motion for mistrial and deny the motion to remove either Ms. Hylton or Ms. Love from the case. I do think that it appears from the questions that there was somebody else present at every meeting. But, you know, Ms. Hylton, that's another option as well. Yes, ma'am. I can't hear you.
Okay. All right. Can you
try that one?
All right. Can you hear me?
That works.
All right. Your Honor, I want to add that we cannot question any other individual that was at that meeting about Ms. Hylton and the way that she asked some of her questions and made her comments. Let me give you an example. Ms. Hylton said, "I was standing to the side because I didn't know you." That's her feelings. That's her reasoning on why she was standing where she was standing. Ms. Hylton also said, "I was just being me." I can't ask Detective anyone in reference to that.
Hang on. Sorry. I mean, I think that each of those was not a statement. It was a question. It was a cross-examination question. And was this essentially like is this your recollection or is this what happened? So it was not her testifying. I'm overruling that objection.
All right. And I just want to add that she also said the purpose of the ex parte meeting. So there's no
Which
way that
he said, I have no idea what the purpose of that meeting was. So, I mean, I understand, but it's overruled. Thank you for the additional making of the record. Anything else?